Gauteng High Court has too few judges for the number of civil matters enrolled, with the earliest available court dates in 2031. The draft directive by Judge President Dunstan Mlambo proposes that cases only be set down for trial if they first undergo mediation. The Judge President joins us now in studio. Thank you so much for making time for us, Judge Mlambo. Good evening.
Good evening, and thanks for inviting me.
So we clearly have too many cases and too few judges. If really we have a scenario where cases or matters have to go through compulsory mediation first before being enrolled in court, how would that assist?
It will assist in the sense that it will sift cases that don't deserve a judicial attention by a judge to be resolved before they land on the trial roll. That's the simple statement of it. And I can expand. I explain in the directive I've issued that our experience is 85% and more of the matters that land on the trial date, having waited for years, settle on that day without requiring any serious intellectual engagement with the issues by judges. They get resolved by being settled, etc. So our view is those matters don't belong on the trial roll in the first place. If they can be easily resolved that way on the trial date, they can be resolved a lot earlier and ensure that litigants who are involved in those matters get relief a lot earlier.
So how would this mediation process work, and who pays for the mediators? Are litigants going to be given that access by the state, or they have to get private mediators?
Well, the scheme we've devised is to use private mediation services. And unfortunately, litigants have to pay. Some objections say this is an added cost. It's not an added cost. If parties seriously engage with the mediation process, they will cut out a lot of additional costs that become factored should the matter go through all the processes until it lands on the trial roll. So it's a necessary cost that litigants have to go through.
And some litigants may argue it's a necessary cost, but it's a cost that they can't meet. What about those, for instance, who rely on legal aid, even when the matter goes through the court?
Well, legal aid has its own internal processes as to how to meet these expenses that happen before the matter is finalized.
Okay.
Yes.
So that's at least the window that's available for those who may not have the resources.
Yes.
So what about, would you require a mediator's report once that mediation process is completed before the matters are enrolled in court?
Yes, because the mediator's report will tell us if there was a serious engagement by the parties with the issues that are in dispute, and whether they are doing their utmost to ensure that they find each other and resolve whatever differences they have on those disputed areas. Yes.
And if there's no mediator's report, does the matter get struck off the roll?
Yes, I think we're saying, that's why we're saying it's mandatory. If parties refuse without any justified reason or basis why they can't engage in mediation, we will refuse to entertain that matter. And I can explain, there's this ongoing view that compulsory mediation is unconstitutional. If you read the discussion paper by the Law Reform Commission, it explains clearly that the right to courts is not a limitless right, and mediation is a justified way of limiting that right and ensuring that disputes get diverted and be resolved in that manner than burdening court rolls.
Or alternatively, some would argue, if government was putting enough resources and was hiring enough judges and capacitating the system, this compulsory mediation maybe wouldn't be necessary.
I don't think I agree with that. In one sense, yes. We've not had an increase in the judicial establishment for some time. I think in the directive I say since 2008. And the work has continued to rise. But I think there's relief in the horizon in terms of adding to the judicial establishments, because I believe the Moseneke committee has finalized its rationalization investigation, and a report has been handed to the minister. The JSC is meeting in a week's time. Hopefully the minister will be talking to us and telling us what the recommendations are there. So that will provide relief in the sense of providing probably more judicial posts. I don't know what that report says, what the recommendations are.
Okay.
But yes, the work has continued to rise. We have less judges that are able to deal with the workload that continues to rise. Yes, that's true.
Okay, we'll come back to that report in a moment. But still on the mediation report, there are some people who are arguing that we've tried mediation before. We've tried to resolve this matter out of court, but it's simply failed. And now we're being forced to this compulsory mediation. What happens to those people who
You are being
explored?
misled, Mr. Manyathelo, by anyone who says they've tried mediation, especially in the High Court context. We have a rule, Rule 41A. That is the mediation rule in the rules, the uniform rules of court. It says each party that issues a summons or an application in the High Court must file with it a notice to the other party to indicate whether they have objections or whether they will agree to go to mediation. It says shall. It's mandatory for them to file that report. But what parties do is to simply say mediation won't resolve without giving it a try whatsoever. And we are giving teeth to Rule 41A to say, actually, it's high time that parties started taking this rule seriously.
So how do we prove, though, that other people have not explored mediation? So people will argue, we tried, for instance, to bring families together to come and discuss whatever issue, or we tried to sit with this other party. Emails have been sent, but they were not responded to, or we tried to sit down, but we didn't reach consensus. How do we actually prove that, okay, you guys have not really fully explored a mediation process of sorts before approaching the court?
The mediation protocol that is accompanying the directive that I've issued, it explains what will become acceptable to us as being an honest and sincere attempt at mediating, right? That report will play a key role in terms of telling us whether parties seriously engaged with the issues in dispute. And those matters whose dates we are taking away from 2026, we know that they filed Rule 41A notices, but we're saying they have an option to file an expanded Rule 41A notice, and it covers a number of areas which they have to cover to persuade us that they have engaged in a serious attempt to resolve their disputes, even where experts are involved. Yes.
What kind of cases, Judge President, normally clog up the system, these civil cases? I know with the road accident fund, that's probably one of the cases that mostly clog up. Are there others, typical cases?
The RAF cases is the biggest chunk of cases that are clogging our roll. And when I say clogging our roll, I mean those are the matters on a normal day. Each of the DJP will allocate not less than 3 trials for that day to a judge who's on that role. Now, 3 trials to be finalized within that day to a judge. Think for yourself, what kind of justice are we talking about? Because the next day, that judge will get another 3. And these are the matters that settle, right? So you ask yourself, why should people insist on applying for trial dates and heaping up all the costs until they arrive at the doors of the court and then settling?
Because it makes sense for their bottom line. They want to make money.
We are not in the business of assisting people make money.
Yeah.
We are in the business of making sure that there's effective access to justice to litigants.
Yeah, and I say that because it's a matter that's been raised as a concern even by the Road Accident Fund. Do you think, and from the objections or the response you've received, especially from lawyers, because the longer matters take in court, the better the bottom line for some of these lawyers. So I imagine some of them are not going to take kindly to this directive. What kind of response are you receiving?
Well, you've said it. I'll repeat what I just said now. We are wanting to emphasize that we will stop providing trial dates that are more than 18 months in the future. Because as we sit to wait 7 years for a trial, having started the process probably 3 years before. That's 10 years. That's unthinkable. So we want to arrest that position. And we are arresting that position to make sure that there's effective access to justice to the parties, the litigants themselves, who are involved in these cases, who need relief.
Yeah.
Yes.
What have been some of the consequences of these civil matters that are clogging the system? I mean, obviously, access to justice, there are matters that you said deserve their attention. I mean, people wait as long as 7 years for the matter to go through the system because of this, the system that's clogged.
Well, it's because the numbers. I was talking to one of the chief registrars today, the Joburg one, who will tell you that in the trial roll, in a week, they received not less than 2,000 requests for trial dates in a week. So there's a lot of litigation out there. And if we don't arrest that situation, we are going to be a mockery of a justice system. And that's why I've decided to take this bold step, controversial as it may be, which I don't think it is, because not to do it now is postponing the inevitable. The Law Reform Commission has published a draft mediation bill that will come with mandatory mediation. So why not do it now?
You mentioned earlier about a report that's, did you say the Moseneke report that's been concluded?
Yes.
And that's probably going to help come up with solutions to resolve this pressure on the system. And I've interviewed the different justice ministers from the time when, even before Ronald Lamola, and then Ronald Lamola came, and then Thembisi Melani, and then the Mamuluko Kubai. They all talk about the plans to capacitate the system. We're going to invest money, get more judges, but it never really happens. I mean, I don't think this is the first report that is done that's going to tell government what needs to be done and tells government what a crisis it is with the pressure on the system. So how hopeful are you that this report is somehow going to bring about solutions that will be effective and practical and implementable?
I think, yes, it may be said that probably there's been a snail's pace response to these issues. But I'm hopeful. In fact, I'm more than hopeful, because we have a Chief Justice who has assured us, as other heads of courts, that she wants to make sure that she addresses these lingering challenges that have been on the table for a long time. She has already initiated efforts to meet with the executive to make sure that they address all these issues. So, talking about that report, we addressed, or we engaged the Moseneke Committee as heads of courts, of other high courts, and explained what the issues are. The biggest one is increasing the judicial establishments in line with the increased workload. So I've not seen that report. I don't think anyone in the judiciary has seen